All right, Ms. Paul and Mr. Wilson, we are ready for your case. Ms. Paul, you may proceed.
Thank you, Your Honor. May it please the court, Beverly Pohl from Nelson Mullins, Broad and Cassell for the appellants Chris Houston and BTL Industries. This case presents a novel version of the situation where a party has two contracts and one of those contracts contains a forum selection clause and the other does not. The trial court denied our motion to dismiss because of the forum selection clause, concluding that the contracts were separate and concluding that the second amended complaint was based entirely on the second contract that does not contain a forum selection clause. But we would argue that that was the wrong perspective. Of course, there's separate contracts, but the question is whether they're related. Because whenever you have a two contract situation, you have to look at the language of the one that contains either.
Ms. Pohl, in this instance, as you correctly point out, we have, at least according to the lower court's findings, we have two separate contracts. We have the 2017 agreement and we have the 2020 agreement, or the stock option agreement. The latter agreement not containing any venue language, unlike the 2017 agreement. My question is, why aren't these two agreements just standalone contracts? They're 3 years apart. There's actually different signatories on each one. One of them has a venue provision, one does not. But what they do have is they have overlapping trade secret restrictions, and the 2020 contract is seeking to enforce those which are spelled out in the 2020 agreement, totally irrespective of what the 2017 agreement. In other words, it seems to me the two can kind of stand alone on their own merits. And in fact, the fact that they each have these restrictive covenants would imply that that's exactly what they're supposed to do.
Well, you say they are overlapping, but in fact, the restrictive covenants are virtually identical. And so I think you have to start with.
So why can't the plaintiff take the choice of saying, I'm here to enforce these restrictive covenants and I'm going to go the 2020 stock option route and to do that? What's wrong with that? They have a right to choose their own forum, do they not?
The simple answer to that question is because the claims in the second amended complaint are related to the first contract. That's the simple answer. And you need to start with the language of the first contract, which says any action that's arising under or relating to any provision of this agreement shall be commenced only in a Massachusetts court. So we basically have agreement from the other side. This is a mandatory forum selection clause. And so the only real disputed issue in this case is whether the claims that are at issue in the second amended complaint are related to.
I'm not sure I totally understand that kind of first principle launching point that your argument leaps from. So help me out with that, because typically forum selection clauses are understood in terms of the contract to which they pertain. In other words, this contract has a forum selection clause, as Judge Black pointed out, another one doesn't, okay? There's an old notion in the law that the plaintiff is the master of their complaint. The plaintiff chooses to sue on contract B, foregoing rights, foregoing a claim that they could have brought under contract A. They are not choosing to present that. They are choosing only to go after these claims. Presumably there's a tactical reason for that.
Because there's
Seems like your argument deprives the plaintiff of the ability to pick and choose what claims they wish to advance and which claims they want to leave by the wayside.
You know, the Lotus parent, although it came in as a plaintiff, Lotus parent is a bit player in the second amended complaint. It's all about the employment relationship with Sinosure.
That may be true, but these are two separate 3-year apart agreements that address different issues.
Not different issues with regard to the restrictive covenants. They are the same. You can set the restrictive covenant.
Well, if you're trying to combine these two contracts and make them into one, why do we need two different sets of restrictive covenants? To me, that would imply that these are separate agreements that have separate covenants.
But they're the same covenants. That's the point. They are exactly the same covenants. And let me back up and focus on for a moment what related.
And what I'm trying to say is I think your argument would be stronger if the 2020 contract did not have any restrictive covenants in it.
It would be stronger.
It would be stronger because then you'd have to look to the 2017 contract, which talks about restrictive covenants, because you essentially you're saying that these two agreements have to be read together. And I'm saying I'm not so sure about that. To me, they look like two separate contracts, one with a venue provision, one without. The plaintiff chose the latter in order to address the grievances that are involved.
That might be so if the restrictive covenants in the 2020 contract superseded the 2017 restrictive covenants, but it explicitly says that they are in addition to and do not supersede any prior.
But it also 3 pages later explicitly says that this agreement is totally self-contained and all the terms and conditions are contained within this agreement. And so there's some conflicting language there. I'll grant you that.
It doesn't really conflict because the merger clause language only deals with prior agreements between the parties to the agreement. So in other words, if there were any prior agreements between Lotus Parent and Mr. Houston, the merger clause would invalidate any prior agreements, but there are none. So that's really not inconsistent with the later or with the earlier language that says these restrictive covenants shall not supersede the previous covenants. So really, let's back up and say when Sinosure entered into this agreement with Mr. Houston in 2017, saying anything related to these restrictive covenants has to be brought in Massachusetts. The question is, what's related to that? And for that, the answer to that, first of all, the answer brief never even addresses that question, but it's the central question in this case. And you have to look to the Jackson versus Shakespeare case from the Florida Supreme Court, because that's the most authoritative and recent discussion of what really it means to be related to. And even in Seifert, which came earlier from the Florida Supreme Court, the court recognized that related to is language that's very broad. And courts have construed related to incorporate tort claims and statutory claims, virtually every kind of claim. And
I think the issue here is what has been pled and what is properly before the court to be adjudicated. I mean, you all in theory could have brought a counterclaim for a deck action, perhaps, to construe that 2017 agreement, and then we might have a different. We might be looking at this a little differently. But that's the 2017 agreement. It's not even before the court, other than you all wishing to bring it in and say, no. I understand that they're suing us on that agreement, but this is what this is really about. But that's not what they pled. Nobody's pled that.
I disagree that it's not properly before the court, because in the context of a challenge to venue, we're not constrained by the four corners rule. The court can look at things.
No, I understand that, but you are constrained, at least to some degree, or at least the court is constrained to deciding issues that have been pled and brought before it.
Well, not just the issues have been pled, but the related issue of whether those claims are related to the restrictive covenants in the Sinosure 2017 agreement. There's never been an argument that contract's not properly before the court.
So to maybe bring in the point then, okay, so suppose the circuit court had just concluded, no, they're not related because they're not being sued on. Why would that be an incorrect conclusion?
Because they are the same, because the restrictive covenants are exactly the same. And they deal with Sinosure, by the way. They don't deal with the Lotus Parent. Lotus Parent's not his employer, and it's all about his contractual relationship with Sinosure. You can't repeat the same restrictive covenants in a later contract and say they're not related to the original contract. They're
Let me ask you a question relating to the way this action was brought. So you have two parties as plaintiffs, which are Cynosure and Lotus. Had Lotus alone brought this action, claiming damages and injunctive relief and so forth for violation of the 2020 contract, is it your position that you would still be able to get venue transferred?
Yes, because Lotus and Cynosure are closely related entities. And the case law is quite clear that non-signatories are bound by a forum selection clause or an arbitration provision when they are a closely related entity. And that's never been disputed in this case.
So if Lotus simply sought a determination that there had been a violation of the covenants and whatever ramifications flow in relation to the stock options, and they only wanted relief in relation to the stock options, would that change the analysis?
If they alleged in that complaint that there had been a violation of the restrictive covenants, I think we'd have the same argument because the claims would be related to the original agreement.
Because it seems to me that, at least initially, your better argument might be that, at least as to Cynosure, because it is bound by the 2017 contract and the 2020 document does not supersede, by its own terms, does not supersede that contract, that at least Cynosure has to be dismissed as to Cynosure, but that's not your position. You believe the whole case has to be dismissed.
Because of the close relationship between Cynosure and Lotus Parent. I mean, Lotus Parent's only interest in the restrictive covenants is to the extent they affect Houston's employment relationship with Cynosure. Because Lotus Parent doesn't have customers in the same way that Cynosure does. It's not his employer. So the interrelationship cannot be ignored. And they, in the original complaint, Cynosure itself alone sought to enforce the 2020 contract.
That's gone. So that was amended. I don't think it may go to a question of what you believe their intent was, but that's not the pleading that's before us.
But both Cynosure and Lotus Parent are seeking to enforce the 2020 contract in counts 1 and 2.
Ms. Paul, let me ask you a little cleanup question on the 2020 contract. We sent an order out last week because the very opening paragraph of that 2020 contract talks about that agreement being subject to the terms of the Lotus Parent Equity Incentive Plan. And I didn't see anywhere in the record where that plan was put into the record or argued or discussed, or I'd be most curious to know what, if anything, it says about venue in that agreement, since the 2020 agreement apparently is subject to the terms of that agreement. Is that in the record?
The document is not in the record, but in order to prepare to answer the court's question, I did discuss this with counsel for Cynosure and Lotus Parent, and I accept his representation that there is no venue provision or no forum selection clause of any type in that document.
Okay, thank you.
I'd like to illustrate what related to means by looking at the two Florida Supreme Court cases that I think best help decide this case. And one is Jackson versus Shakespeare, where a party contracted to buy property. And the court talked about the difference between arising under and related to, and talked about how broad the term related to is, and said what it means, there has to be a nexus to the contract. And there, where the problem that arose between the parties was there had been a representation made that there was no wetlands on the property, and it turns out there were. And then there were various tort claims brought, misrepresentation claims, fraud claims, And the court said, that is subject to the arbitration agreement because it's related to, even though it's a tort. And contrast that with Cipher, the earlier case, where the contract between the parties had merely been to build a house. And the terms of that contract had to do with the price and the size and the payments and nothing at all about personal injuries. And later, the owner of the property was killed when a car was left running in the garage and the emissions from the car with carbon monoxide killed him. And the court said that personal injury claim is not related to the contract because it could have happened to anyone in the house. They could have been killed, and it was only fortuitous that he had entered into the contract to build the house. And in Seifert, they said the personal injury claim was not related to and was not subject to arbitration. But in both cases, the Florida Supreme Court recognized how broad related to is. And here, every single claim in the second amended complaint relies on the same facts. And all of those facts have to do with the employment relationship between Houston and Sinosure. And that relationship is governed by the 2017 contract, and it is clearly related to.
Ms. Cole, you have 4 minutes left. Do you wish to reserve any time for rebuttal?
Yes, I would like to reserve 3 so that I can keep going for 1 more minute, Your Honor. The other case, there's really no case quite like this one, but that doesn't mean that our argument fails. It just means that it's very odd to have 2 contracts that have precisely the same terms of them, one with and one without a forum selection clause. And I think what this court has to do is take a practical view and say, you cannot pretend, our Sinosure cannot pretend that the first contract doesn't exist. And what it says is anything related to those restrictive covenants has to be in Massachusetts. And you simply cannot look at this second amended complaint that incorporates the same facts in every claim, whether tort or contract or statutory, and say that it's not related to. I'm going to reserve.
That would be a good point to stop to reserve your 3 minutes. Very good. Mr. Wilson?
May it please the court. Good morning, Your Honors.
Good morning.
Your Honors, this case presents basically an argument like this. I buy a ticket to a show in Tampa, and I buy a ticket to a show in Massachusetts. I show up to the show in Tampa, and they say you can't come in because you've also got a ticket to the show in Massachusetts. And I tell them, well, I've got 2 tickets. I purchased them separately. I paid for them separately. Why can't I just come into the show in Tampa with my Tampa ticket? And their response is it's the same show. Your Honors, I suggest that no law supports that, and it doesn't make any common sense.
There's a little problem with that, though, isn't there? In that the contract from 2020 says these covenants shall be in addition to and shall not supersede the covenants set forth in any other agreements which the employee and the company or an affiliate of the company are or hereafter become parties. So it's not exactly 2 separate standalone tickets, is it?
Your Honor, I respectfully disagree. I think that language makes it clear that they are 2 separate agreements. What they are saying, what the parties agreed to.
Let me ask you, how does shall be in addition to and shall not supersede support that analysis?
Because it's saying you have 2 separate obligations. The contracts are different in innumerable ways.
Mr. Wilson, how are they 2 separate contracts when it says these covenants are in addition to? Doesn't that, a fair reading of that language mean under this and under that, here's our agreement?
No, Your Honor, whenever you have subsequent contracts that cover the same subject matter, the default position is that the later contract supersedes the earlier contract.
Absolutely, when it says that, except in this case, it specifies shall not supersede. You just said when it supersedes it. This contract has language saying it shall not supersede.
Right. Because the presumption is that the later contract supersedes the earlier contract.
And the
In
presumption
this case,
by the terms of the second contract.
in this case, the parties agreed that the later contract would not supersede the separate earlier contract, that it is an addition to. Addition means that you have two instead of one now. So you have the earlier contract, and in addition to that, you have the later contract. The later contract has not replaced the first contract. It has added a second contract to it. Your Honors, that's what the lower court found and what is correct. These are two separate agreements. The list of distinctions we've set forth in a chart in our answer brief that shows the many differences in the two. And
Well, I'll just tell you, Mr. Wilson, it does seem a little counterintuitive, odd, square peg in a round hole, that you are enforcing restrictive covenants out of what is basically was an option contract, rather than the actual employment agreement itself, which is what clearly gives, is clearly the genesis of all of this. I mean, I said it earlier, you all are the master of your complaint, but can you help me out with that concern? It does seem a little indirect.
Your Honor, I think the easiest explanation for that, and the most direct explanation, is that one of the major differences is that the restrictive covenants in the option agreement, because we gave additional consideration for that, is that several of them are 2 years instead of 1 year. So it is a much more forceful, powerful, valuable to us agreement. And if you're choosing between a 1-year agreement and a 2-year agreement, everyone I know is going to choose the 2-year. So we gave the additional consideration, we got an additional year. And again, that's not the non-compete, that asks for non-solicitation of customers, non-solicitation of employees. Those are 2-year provisions, and that's why that's more favorable.
But and I can accept that argument as to both Cynosure and Lotus as to the time frame and the enforcement, because I think that modifies the 2017 agreement. But there's nothing in here, at least as to Cynosure, that writes out of the parties' relationship that's documented by these two contracts, the venue clause.
Your Honor, and the point there is they are two complete agreements, not just separate, but complete. And venue exists. Most contracts don't have a venue provision. Most contracts don't have an arbitration provision.
So let me interrupt because I want to make sure I understand. So you're saying that these two contracts have to be read. I think what you just said was they do need to be read together because they become a complete package. Am I understanding that correctly?
No, Your Honor. That's definitely not what I said, what I intended. They are two separate contracts, and that's why I'm just trying to stress what the lower court found was they were not only separate, but they are complete. If some term was missing from one of the two contracts, that would create a different situation.
Okay, so
there's no argument that there's a missing term.
Well, there is a missing term, which is there's a venue provision in the 2017 contract that is not in the 2020 contract. Is that a missing term?
Absolutely not. There are thousands of contracts with no forum selection clause.
So there's nothing in the 2020 contract that replaces the venue provision from the 2017 contract.
Would not use the word replace, but there is no forum selection clause in the 2020.
There's nothing that supersedes the forum selection clause from the 2017 contract.
The failure to select a forum in the contract effectively supersedes it because venue is established by statute.
The contract says these covenants are in addition to and shall not supersede. You can't read it selectively. Either it supersedes or it doesn't. And there's a venue provision in the 2017 contract, and there is no effort in the 2020 contract to overwrite that.
And if we were suing to enforce the 2017 agreement, I could point to nothing in the 2020 agreement that changed the forum selection clause. in the 2017 agreement.
But Sinosure is not a party except by interpretation to the 2020 agreement. So it is still bound by the 2020 to the 2017 agreement, no matter how you slice it. And let me just add that I understand what the complaint says, and the complaint says repeatedly that in count 1, it is, let me slide over to it, that it is for breach of employment option agreement restrictive covenants, which is the 2020 agreement.
Right.
But it does go forward and say that the, where is it? Houston solicitation of Sinusure's employees is in violation of his restrictive covenants. Threatened solicitation is violation. Confidential information is violation. And if the two agreements have to be read together because one is not separated by the other, but is not eliminating the 2017 agreement, it seems to me that Sinusure's remedy is restricted as far as the venue clause in the 2017 contract.
Your Honor, I just disagree. I don't think any of the law supports that. And I would also focus on the language. I don't think you have to get to that because they're two complete contracts and they're separate.
Let me ask you this question, and I wrote a question here on the 2020 agreement and that I still have in context of Judge Silverman's question as well. On page 1 of the 2020 contract where it says these covenants shall be in addition to, what does these covenants refer to? Because we've just come off of a paragraph that talks about covenants. Is the venue clause even part of, included in that comment, in that passage? These covenants shall be in addition to and shall not supersede. To me, that was referring to the restrictive covenants that was the paragraph preceding, and the venue clause isn't even part of the equation.
I would certainly
And
agree
I
with
don't
that.
see, and I'm not sure you can I'm not sure it supersedes it when it doesn't say anything at all about it in the 2020 contract. And I don't know whether these parties negotiated under these stock options by giving up their right to the Massachusetts venue or not. It's unclear. The two are not a model of clarity, but I'm not sure that that passage from the 2020 contract even applies to venue.
I think that it would not, Your Honor, because there is no venue form selection clause in the 2020. So whatever it's referring to, it could not be referring to a form selection clause.
So then despite the language shall not supersede, your argument is that in fact it does supersede the 2017 contract as to the venue provision.
No, Your Honor. My argument is that there are two separate complete contracts. The form selection clause in the 2017 agreement is still valid as to the 2017 agreement. If we were suing to enforce that agreement, we would be bound by that form selection clause because it has not been superseded. We are not suing to enforce the 2017 agreement. We are suing to enforce a separate agreement with no form selection clause, which under the case law and common sense defaults to the venue provisions of Florida statutes. Your Honors, in addition, the language, counsel referred repeatedly that, well, it's broad because it says, this is 2017 now. It's broad because it says related to. Related to what? Well, if you read the provision, it's at appendix page 30 and 31. It says related to a provision of this agreement, referring to itself, the 2017 agreement. It says the form selection clause applies to any claim concerning a provision of the 2017 agreement. This cause of action, the case before you, does not concern any provision of the 2017 agreement. In fact, the 2020 agreement, which is before you, did not even exist at that time. So obviously when the parties agreed to a Massachusetts forum for the 2017 agreement, they were not contemplating that, well, this will also apply to any other agreements we enter into in the future. If they had anticipated that, they could have said it. They could have used broader language and say this will apply to anything that arises out of the employment relationship. This applies to anything that arises out of our relationship. There are lots of terms that could have been broader, but they are not the terms that were used. They were not the terms that were agreed on.
I'm curious about one allegation at the end of paragraph 11 of the second amended complaint, which says Houston not only breached his fiduciary duty of loyalty to Cynosure, he violated 2 separate express contracts not to compete, solicit employees and customers, or misappropriate Cynosure's confidential information. How do we read that and not bridge the gap, to use Judge Lucas's term of the day, bridge the gap between the 2 contracts?
Judge, that is a fact, that if he breached one, he probably breached the other. It is not a crucial fact. It's probably not an ultimate fact, but it is a fact. We allege that. That does not change the fact that there is no claim based upon that agreement. In fact, the original complaint, and I agree heartily with your observation that we're past that, the second amended complaint is operative. But the original complaint, we allege that he had this prior agreement in 2017, and we affirmatively allege, but there's a Massachusetts forum selection clause. We were just trying to clear this up in advance. We know we're not suing under the 2017 because that would be in a different forum. Because of all the difficulty it caused, we took it out. But the fact that it's out there, the fact that it exists, the fact that he may have breached that too, doesn't change the fact that, as you said, we are the master of the complaint. We chose to bring the case in Florida, knowing that if we bring the case in Florida, we are restricted to the 2020 agreement with no forum selection clause. And as I responded to Judge Lucas, it has the added advantage that the restrictive covenants are materially different and longer in any event. Now, I know your honors have also in the prior, some of the arguments said, well, what guidance would we be giving to the trial court or to the other trial courts if we were to reverse this and tell them to do something differently? Keep in mind that these 2 agreements, among their other differences, have different substantive choice of laws. So what they're telling you is that when I bring a claim in Florida under the 2020 agreement, which is subject to Delaware law, you have to look back at a 2017 agreement, which is subject to Massachusetts law, and somehow merge these together and figure out which terms bleed over and which terms do not bleed over, and which law applies to which terms which bleed over and which terms do not bleed over. I cannot stress enough that that seems like a poor idea, and one that's certainly not required by the law, and it's certainly not required by the parties' contract. Parties entered into 2 different contracts for a reason, and there is nothing remotely incomplete and final about either of these 2 contracts. We have the opportunity to enforce one in Florida and one in Massachusetts.
Mr. Wilson, in the original contract, paragraph 9G, which I think Ms. Pohl was referring to earlier, it says that any action, suit, or other legal proceeding which is commenced to resolve any matter arising under or relating to any provision of this agreement shall be commenced in Massachusetts. Because both contracts have covenants not to compete and non-solicitation agreements, doesn't the 2020, the lawsuit under the 2020 contract also relate to a provision of this of the 2017 agreement, in that both deal with restrictive covenants, non-solicitation, and so forth?
No, Your Honor. By choosing to enforce only the 2020, we do not have to refer to any provision of the 2017. The court does not have to refer to any provision of 2017. No one has to refer to the 2017.
But don't they relate to one another? I mean, that's the language that's used, is arising under or relating to any provision of this agreement.
No, I don't think that's a reasonable interpretation of relating to a provision of this agreement, when a provision of that agreement could not exist and it wouldn't change our rights under the 2020. No matter what the 2017 says, it's not going to change the restrictive covenants in the 2020.
But the
You
2020
don't have to look at it.
It does seem to me that the 2020 contract does the non-competition, non-solicitation, confidentiality. Those provisions in 2020 seem to me on their face, and it doesn't seem to be an unreasonable interpretation that they relate to the 2017 contract.
Look, linguistically, certainly relate is extremely broad.
Who prepared the contracts? Does the record, I mean, the record may not tell us, so if it doesn't tell us, you don't need to tell me. But I'm guessing that this contract, both these contracts were probably prepared by your client. So to the extent there's some confusion, I mean, your client seems to have engendered that confusion.
Your Honor, I don't believe respectfully that there is any confusion. Again, these are separate contracts. They are complete contracts. One has a forum selection clause that specifies Massachusetts. The other doesn't. So as a matter of law, it becomes Florida where the cause of action accrued. I don't think there's any ambiguity in either of those two contracts. It is only the effort to merge them together that creates terrible ambiguity. As I said, how do you merge a Delaware law agreement with a Massachusetts law agreement in a Florida court and figure out which law to apply? I don't think there's an answer to that question. That's why you don't take two separate agreements, complete on their face. Look, Mr. Houston was employed by my client for, I think, 13 years, which means he probably has agreements that predate 2017. If we go back and get all of those and see what state's law applies and begin shifting provisions from one to the other, that's a Pandora's box with no outcome for anybody except a great deal of unpredictability and uncertainty, something they tried to avoid by drafting specific contracts. I didn't draft these. I might have done it differently. They may do it differently in the future, but they're clear enough on their face to say, you agreed to X in this agreement, and this is a complete contract. And under Florida law, Delaware law, or Massachusetts law, these are complete contracts and should be enforced, but enforced separately. To go back to my analogy, I should be able to go to both shows, even if it is the same show. If there are no further questions, I will.
Ms. Pohl, you have 3 minutes for rebuttal.
Counsel for Sinosure made an important admission, which was that conduct that violates the 2020 restricted covenants necessarily violates the 2017 restrictive covenants. And if that doesn't prove that they're related, I don't know what does. But you could look to paragraph 43 of the second amended complaint, which says that in connection with his employment with Sinosure, Houston entered into the employee option agreement effective 2020. In connection with his employment with Sinosure, these are related to the Sinosure agreement and the Sinosure restrictive covenants because they are the same restrictive covenants. And I think that your perspective is important. He keeps saying, look what we're trying to enforce. We're trying to enforce the 2020 agreement. That's not the question. The question here is, because the 2017 agreement exists and because the forum selection clause encompasses claims that are related to that, do the claims in the second amended complaint relate to the original contract? That's the right perspective. Another case that the court needs to take a close look at is Gonzalez. I understand it's a federal case, and Sinosure has argued that it didn't apply Florida law, but he's also not said that Florida law varies in any substantial or significant way from the law that was applied in Gonzalez. And Gonzalez said, you can't pretend another contract doesn't exist when in fact it's related to and has to be construed at the same time. With
Take about 15 seconds to conclude.
regard to choice of law, that's simply not a question that's before the court. We don't know whether there's any difference between Delaware law and Florida law and Massachusetts law. And so that's not a problem for this court to resolve. It may or may not be a problem for wherever this case lands, but it's not something that should affect this court's decision. For all these reasons, the trial judge was wrong in saying these were separate contracts and that was decisive. They're related contracts and the order should be reversed.
Very good. Thank you both, Ms. Pohl and Mr. Wilson. We are going to take about a 10-minute recess and we'll resume